Do women employees who have been one-time victims of serious sexual offences such as molestation or sexual assault at workplace need to file a complaint against the alleged harasser within 3 months of the incident, as mandated by the Prevention of Sexual Harassment of Women at Workplace Act, or POSH? Well, as per a latest ruling of the Madras High Court, it's a no. Delivered last week, this verdict has held that a serious isolated incident of sexual harassment that results in grave mental trauma and stress to the victim can be reported and investigated anytime and not necessarily within 3 months of the alleged offence, which is a requirement under the POSH law. Hello, my name is Bhadra Sinha, and in this video, I will give you more insight into this judgment. As you are aware, POSH Act was enacted in 2013 to protect women from sexual harassment and provide a safe and secure work environment. Besides, it also lays down a redressal system to deal with complaints of workplace sexual harassment. POSH makes the constitution of an internal complaint committee, or the ICC, compulsory in every organization that has 10 or more employees working for it. There is also a mechanism underlined by which complaints can be heard by local district committees set up by the government. Under Section 9 of POSH, a complaint to seek action against the harasser can be filed with the ICC within 3 months of the last incident of harassment, and in case of a series of incidents, within a period of 3 months from the date of last incident. To be sure, POSH is a civil remedy, and standard of proof under it is not as severe as it is in a criminal law. The impact of the harassment is given more weightage than the intent behind it. Now, in the given case before the Madras High Court, the complainant, who works with the state police, was sexually assaulted by her colleague in 2018. According to her allegations, the accused had forced himself upon her during a visit to her house. Thereafter, he used to frequently call her up and make sexually colored conversations, apart from sending her WhatsApp messages. It was only after getting support from her co-employees that she gathered the courage to register a complaint in October 2022, in which she also opened up about the sexual assault. Now, she gave this complaint to her senior, who then referred it to the complaints committee, which recommended disciplinary action against the violators and his suspension until the departmental inquiry against him was on. Challenging this inquiry, the errant police officer raised 2 grounds to question the report before the High Court. First, he said the POSH proceeding was time-barred since the alleged cause of action arose in 2018, while the complaint was filed in 2022. He then complained that he was not given a chance to cross-examine the complainant or the other women employees who appeared as witnesses before the ICC during the hearing. After hearing both sides, the Madras High Court bench of Justice D. Bharata Chakravarti partially allowed the petition. It accepted the accused's plea that he should have been given a chance to cross-examine the complainant and the other witnesses. Referring the matter on this account back to the ICC, the judge laid down measures to ensure the complainant and others are not exposed to the accused when they are cross-examined. But more importantly, Justice Chakravarti rejected the assertion that the inquiry was vitiated because it was time-barred. Giving a liberal interpretation to the POSH law to cover instances involving serious allegations of harassment at workplace, the judge said victimization of a woman at workplace could be treated as a continuing offence if the accused is charged with sexual assault or molestation. Therefore, the victim need not meet the legal mandate under Section 9 of POSH Act that sets a 3-month deadline to report the misconduct and seek action. The court drew a distinction between a case of an isolated incident of misconduct, such as passing lewd or inappropriate remarks, and a case where serious allegations of sexual assault or molestation are made. It observed that in the first category, the victims cannot be permitted to withhold and exercise their right to remedy to their wish and time, which means that the complainant has to strictly comply with the deadline provision in POSH Act. However, in case of serious allegations, The same would be treated as a continuing misconduct until the situation is redressed or brought to the notice of the appropriate authority. In this circumstance, the court said, every day would give rise to a fresh cause of action. According to the court, an act of misdemeanor where the aggressor is charged with heinous sexual offence pushes a woman to a dilemma not to reveal or complain due to fear of secondary or tertiary victimization. Calling sexual harassment a pervasive and a hidden social problem, the court said it not only undermines a woman's authority at the workplace, it also has deleterious consequences for a woman's mental and physical health. In many instances, the victims have reported depressive symptoms a decade later, the court noted, as it made out a case to broaden the law's application. In the present case, the court found that the complainant had suffered from extreme mental agony post the assault, which had increased day by day. It was upon counseling by her co-employees that she opened up to talk about the assault she had suffered. A preliminary departmental inquiry had also revealed prima facie grounds to proceed, and it was thereafter a criminal case was lodged against the errant police officer. Despite assurances by the employer and everybody, the copy of the FIR with the victim's name was shared on a YouTube channel. This further aggravated her anxiety as she got concerned about her son finding out about the incident. In such a scenario, the court refused to get swayed by discrepancies and hyper-technicalities while holding overall fairness of the inquiry as supreme. Timelines in a law, it added, are meant to expedite prompt action and not to entitle a delinquent employee to question the proceedings, it said. Thank you so much for watching The Print. Do subscribe to our YouTube channel for more updates.